Okay, well, we've just gone 12:30 and I think we'll have a few more people who will probably keep joining us, but I will just make a start just so that, as I said, we've got some great speakers and we do want to make sure people have time to ask questions. So good afternoon, everyone. For those of you who don't know me, my name is Corinne Dobson and I'm the CEO of ACT Shelter. I'd like to begin by acknowledging the traditional custodians of the land from which I'm joining you today, the Ngunnawal people, and pay my respects to the elders past and present, recognising that sovereignty was never ceded. I also pay my respects to any other Aboriginal people or families with connection to the lands of the ACT and region. So since the introduction of the ACT's landmark Human Rights Act in 2004, ACT Shelter, alongside many other community organisations and advocates, has consistently called for the right to housing to be explicitly recognised in that legislation. It's our long-standing and deeply held position that everyone deserves access to safe, secure and affordable housing, and that this should be recognised as a fundamental human right in our laws and policies. So now, more than 20 years since the ACT Human Rights Act was passed, we have a historic opportunity to make that vision a reality. As many of you will know, a bill was passed in the ACT Legislative Assembly last month that proposes to incorporate the right to housing into our Human Rights Act. If passed, the ACT would become the first jurisdiction in Australia to legally recognise housing as a human right. So to help us understand what the bill entails, why it matters and what it might mean in practice, I'm really pleased to be joined today by an outstanding lineup of speakers from the ACT Human Rights Commission and from Canberra Community Law. And following the presentations, we will open up to questions from the audience. And so to make sure we allow enough time for this, I will now hand over to our first speaker, Dr Penelope Mathew. And just before I do that, I should to just please, if you can mute your mic if you're not speaking, that would be much appreciated. So Dr Penelope Mathew is the ACT Human Rights Commissioner and President of the ACT Human Rights Commission. Welcome, Dr Mathew, and over to you.
Oh, thanks very much, Corinne. I too would like to acknowledge the traditional owners of the land on which we meet and pay my respects to elders past, present and emerging. I'd also like to acknowledge the leader of the Greens, Mr Shane Rattenbury. So any tricky questions, over to him, please, as he's introduced this very interesting and important bill. So as you're all aware, the ACT has had a Human Rights Act since 2004. And it was a groundbreaking move to bring home the rights set out in international treaties to which Australia is a party. Over time, the Act has evolved significantly, and the list of rights and mechanisms of enforcement have expanded. So, for example, and the Greens were very important on this one too, the new right to a healthy environment came into force in March this year. Despite these significant developments, key rights are still missing from our Act, and one important right that's missing is the right to housing, despite the fact that in the mid-70s, Australia became a party to the key UN treaty on these issues, the International Covenant on Economic, Social and Cultural Rights, and that protects the right to adequate housing as part of a broader right to an adequate standard of living in Article 11. So the ACT Greens have introduced a bill into the Legislative Assembly to add the right to housing. It's currently the subject of an inquiry by the Legislative Assembly's Standing Committee on Legal Affairs, and submissions are due to the committee by 5 p.m. on the 30th of May. I think it's also important to acknowledge that the ACT Labor policy platform included the commitment to have a roadmap for inclusion of the rest of the key socio-economic rights in the international covenants included in the Human Rights Act. So in theory then, I think the Greens are simply bringing forward one very important right, and we might hope that there would be support across other parties for this right. And I'm sure some great submissions from community organisations might help to make that happen. The bill is very short and sweet, but there might be some words in there that require a bit of explanation. And I don't know who's in the audience. I don't know I know you're all very interested in the right to housing, but I don't know, whether you come at it from a lawyer's aspect or a different kind of expertise. So I'll just go through it briefly. The main provision of the bill, which will add or would add section 27D to the Human Rights Act, says that everyone has the right to adequate housing. So one question you might have in your minds is, well, what does adequate actually mean? It then lists some elements of the right that are immediately realisable. It's a non-exhaustive list. It draws attention to the right not to be discriminated against with respect to housing, not to be unlawfully or arbitrarily evicted from the home, and not to have an essential utility unlawfully or arbitrarily withdrawn. So again, you might have a question about, well, what does immediately realisable mean, and what's the significance of referring to that? Finally, the bill provides for a review of the new right within 5 years of the section coming into force. So that's it. As I said, it's a very short and sweet bill. So in a moment, I'll talk about what those words in proposed section 27D mean, and I'll discuss more broadly what a right to adequate housing means. It does not mean that the government has to provide free accommodation to everyone, and I think that's an important message for the community to hear. But before we go into all of that, perhaps it's useful to give some context about the Human Rights Act, why it's important, and why it's important to add the right to housing. Now, obviously, the first point is that the Human Rights Act sets out a list of rights. Many of the rights are traditional civil liberties, like freedom of expression or the right not to be arbitrarily arrested or detained. So these are traditionally thought of as civil liberties, and they're about keeping governments out of citizens' lives, essentially. In addition to civil and political rights, there are also cultural rights for minorities and significantly for Aboriginal and Torres Strait Islander peoples. And finally, there are some social and economic rights. These rights enable people to participate socially and economically. In the ACT's Human Rights Act, we have the right to work in section 27B, and we have the right to education in section 27A. But we don't have the right to the highest attainable standard of health, and nor do we have the right to an adequate standard of living or the right to housing. Now, there are some civil rights that can be important in protecting socio-economic rights. So the right to privacy, which is enshrined in our Act in section 12, protects against arbitrary interference with one's home. And public housing tenants in the ACT have raised section 12 to protect them against evictions from public housing, for example. Now, protection against removal from an existing home is an important safeguard, but the right to adequate housing is about more than that. It's also about the availability of affordable and decent housing. In addition to the list of rights, the Human Rights Act has important impacts on government policy, legislation or lawmaking and decision making. In the first place, all new legislation is effectively vetted for compatibility with the Act. When the government introduces a new bill into the Legislative Assembly, it must be accompanied by a statement of compatibility. So far, we've not had a government deliberately introduce legislation that they think is simply incompatible with our Human Rights Act. And I think that's important because there are two other jurisdictions, Victoria and Queensland, that have Human Rights Act, and we have seen governments there introduce legislation that they acknowledge they think is simply incompatible with human rights, and they're going to go ahead and do it anyway. So I think that speaks to a quite a healthy human rights culture here in the ACT. In addition, all existing laws passed by the Legislative Assembly must be interpreted in a way that's compatible with the rights in the Human Rights Act, insofar as that's possible, consistently with the purpose of the legislation being interpreted. The next significant feature of the Human Rights Act is that ministers of government, public servants, police officers and other public authorities must act consistently with the rights set out in the Act and give proper consideration to them when making their decisions. Finally, in most cases, with the exception of the police who are part of a federal organisation, the AFP, complaints can now be brought to the ACT's Human Rights Commission. And in addition, with the exception of the right to a healthy environment, at least initially, legal actions can be commenced in the Supreme Court about violations of those obligations on public authorities. The Human Rights Commission, of course, can seek leave to intervene in court cases involving the Human Rights Act, and we've done so in a number of important cases. So by setting out Human Rights Act in one Human Rights Act, the ACT has sought to guide all policy, legislation and decision making, and it's given members of the public ways of complaining when decisions are made without due regard to human rights. When Mr Rattenbury introduced the bill into the Assembly, his explanatory memorandum stated that fundamentally the bill will compel the government to think differently about housing, reframing decisions about housing through the lens of social need rather than private profit. And that is certainly consistent with the way that the supervisory body of the Covenant on Economic and Social Cultural Rights, the Committee on Economic, Social and Cultural Rights, sees the right to housing. It's about a right to live in peace, security and dignity, and rather than it being seen as a commodity or, you know, an aspect of wealth. Surely we should include the right to housing in our Human Rights Act as part of the guidance to policy makers, lawmakers and decision makers. And perhaps if we'd had this guidance in place across Australia, we might not be in the middle of the housing crisis that we now find ourselves in. So let's come back to the language in the bill, the meaning of the words adequacy and immediately realisable. And being a lawyer, of course, I'm going to start with the second first. So there is some leeway for governments to fulfil socio-economic rights, like the right to housing, gradually. This is known in international law as the obligation of progressive achievement or progressive realisation. This is in contrast with the fact that some rights or some aspects of rights are immediately realisable. With respect to civil and political rights, the obligations are immediate. The major UN treaty that protects these rights, the International Covenant on Civil and Political Rights, simply says in Article 2 that the rights must be respected and ensured. By contrast, the concept of progressive achievement features quite strongly in the International Covenant on Economic, Social and Cultural Rights. So Article 2 of the Covenant on Economic, Social and Cultural Rights talks about a country taking steps to the maximum of its available resources with a view to achieving progressively the full realisation of the rights. Through this clause, the treaty acknowledges that some countries have more resources than others, and it might take time, therefore, to fulfil socio-economic rights. But there is an immediate obligation to take deliberate, concrete and targeted steps to fulfil the rights in a reasonable time frame. Countries need to develop a plan to fully realise the rights, take steps immediately and devote the maximum available resources to their realisation. In an affluent country like Australia, more effort and resourcing needs to go into housing, and we all know it. It is important to acknowledge that the ACT has been taking steps to realise the right to housing. I could talk about quite a few things, but I'm not quite sure how I'm going for time, Corinne. I've just thrown the stopwatch out of the...
You've still got a few minutes to go.
Okay,
yeah, you've got about, more than 5 minutes, so that's all right.
So, for example, there's the ACT's housing strategy and implementation plan. There have been recent reforms to tenancy legislation to protect against arbitrary evictions through the removal of no-cause evictions. Those are all important steps taken to protect housing. Now, if a country actually goes backwards with respect to fulfilment of economic, social and cultural rights, the country concerned bears a heavy burden to justify those regressive steps. As Jessie Homan, who's an academic at the University of Technology, Sydney, writes, if housing is increasingly unaffordable over time, this is prima facie retrogression and serious evidence that the state is not meeting its obligations under the covenant. And many, like Kevin Bell, Alan Kohler and others, have pointed to the fact that we are really going backwards in Australia in terms of affordability of housing. The Committee on Economic, Social and Cultural Rights has also spelled out there are certain minimum core content for rights, a minimum level below which no country can fall, not even countries that are much poorer than Australia. So with respect to housing, there's an obligation to provide basic shelter and housing, and any country in which there are significant numbers of homeless people is prima facie in breach. And so if we look at Australia and even here in the ACT, there are far too many people who are street homeless and indeed suffering other forms of homelessness. Okay, so another question you might have is, why does the bill draw attention to these immediately realisable aspects of the bill? Shane might like to address that during the question and comment time. But what I will say is that you may have noticed in debates about inclusion of socio-economic rights, both at the federal level and at state and territory level, there's been some debate about whether only immediately realisable aspects of the right are judicially reviewable, particularly at the federal level. I think these concerns are actually overblown, even at the federal level, and they don't actually apply in exactly the same way to territory courts. In the explanatory memorandum, Mr Attenbury actually doesn't make a distinction between courts' ability to adjudicate something that's progressively achievable versus immediately realisable, but just gives examples of what are immediately realisable aspects of this right. In our submission on the initial consultation, the Human Rights Commission said we'd actually prefer them to appear in a note, not to give them so much prominence. But I don't think really that the bill is saying we're running away from progressive achievement altogether. In stark contrast to the right to education in our Human Rights Act, which does limit the right specifically to only two immediately realisable aspects. Okay. Another aspect of the right, and I'm going to finish very shortly, I promise, Corinne, is the adequacy of housing stock at present and into the future. The Committee for Economic, Social and Cultural Rights has spelt out 7 aspects relevant to the question of adequacy. They are legal security of tenure, availability of services, materials, facilities and infrastructure, affordability, habitability, accessibility, location, and cultural adequacy. So just to pull out one of those elements, the habitability of the ACT's public housing was highlighted in the lead up to the 2024 election. ATCOS and ACT Shelter published an election platform noting that chronic underinvestment in public housing stock means too many properties are in a state of disrepair or aren't appropriate to meet the needs of those housed. The Commission's work has also seen examples of where a right to housing could have made a difference to decision making. And we've given some examples in for the consultation draft, and no doubt we'll do so again when we make a submission to the committee. The examples include victims of sexual or family violence at risk of becoming homeless or continuing to live in violent or unsafe situations, and older persons or persons with disability presented with unsuitable properties or facing delays in maintenance. Having a human right to adequate housing in our Act brings international standards to bear on what's happening with respect to housing in the ACT. It imposes obligations on public authorities. It has a complaint mechanism and possibilities of litigation, and it should be part of the Human Rights Act. And I'll end there.
Thank you so much, Dr. Mathew, for that compelling and clear overview of the Human Rights Act. And as I said earlier, we will have an opportunity for questions once we hear from the presenters. So do please file away those questions. We will have an opportunity to ask those. So I'd now like to welcome our next presenters, Ruby Liu and Rachel Clark from Canberra Community Law. Ruby is a solicitor working in social security law, and Rachel is supervising solicitor for the Darawang Human Rights Program. So welcome, Ruby and Rachel.
Thanks so much. So I'm going to start off. My name's Ruby, and I'm a solicitor at Canberra Community Law. And for those of you who don't know us, we're a community legal centre, and we provide free legal advice and assistance to people in the ACT on low incomes. And I'm also speaking to you this morning from Ngunnawal country. And I wanted to start by recognising that the housing and homelessness crisis is happening on First Nations land, and that Aboriginal and Torres Strait Islander people have a right to self-determine solutions to the housing crisis in their own communities. At CCL, we regularly represent Aboriginal and Torres Strait Islander people, including elders, who face housing rights issues like race discrimination, overcrowding, difficulty getting repairs and eviction. And my colleague Rachel will be speaking more about the work of Darawang after this. So I'll give you a bit of an overview of what we do at CCL. So we run a number of services, but we specialise in providing housing law assistance to people in the ACT who are homeless or at risk of homelessness, and people who live in public, social and community housing. And we capture also people who live in caravan parks, crisis accommodation and supported accommodation. And our organisation, like many of the organisations who are here today, has been fighting for a right to housing for the ACT for a long time. And there are three key points that I wanted to make this afternoon about a right to housing for the ACT. So the first one is that a right to housing is not a great leap for the ACT. We already have a human rights framework, as Dr. Mathew has just spoken about, and ACT law and policy protects housing rights to an extent. But the second point is that there are gaps, and our clients are often the people who end up falling in the gap. So a right to housing is a really important next step for the ACT. And the third point I want to make is that a right to housing is critical for our clients who are on the front line of the housing and homelessness crisis, but it will also have economic and social benefits for the whole of the ACT community. So we're asking the question, we were the first state or territory in Australia to get a Human Rights Act. Why shouldn't we be the first to have a right to housing? So the first point about the right to housing being not a great leap for the ACT is part of our job at CCL is to assist people who live in social housing to use the law to protect their housing rights. And as Dr. Mathew said, housing rights are protected in the ACT to some extent. So tenants are protected from forced evictions. A landlord usually has to apply for a tribunal order to evict someone, though that doesn't apply to occupants. Landlords are required by law to provide habitable premises, and tenants can seek compensation for breaches. Rent increases are limited by law, which protects affordability. The Discrimination Act protects against discrimination in the provision of accommodation, which includes housing, etc., etc. And as Dr. Mathew said, public authorities have human rights obligations under the Human Rights Act, as do private bodies that perform public functions. So for lots of our clients, their housing providers have human rights obligations, which means we can use human rights law arguments when we try and prevent people from being evicted from social housing, when we try and get people who are homeless or in severe rental stress into social housing, and when we assist people who are living in social housing to get repairs done to their homes to make them safe to live in. But since we don't have a right to housing in the ACT, we have to be a little bit creative and use other human rights to try and protect our clients' housing rights. That's not actually that hard because all human rights depend on having adequate housing. If you don't have a safe, secure, habitable, affordable place to live, it's going to be really difficult for your kids to go to school and access their right to an education. If you don't have a safe place to live, it's going to be really hard for you to access your right to go to work, etc., etc. So at CCL, we use the Human Rights Act, I think it's fair to say, every single day. And we're constantly reminding decision makers that tenants and occupants and people experiencing homelessness have human rights and that those rights need to be considered in decisions about their housing. So human rights are a really effective advocacy tool. And the framework that we have does protect housing rights to an extent. But there are gaps, and that brings me to the second point. And I'll give you an idea of the kinds of gaps that we see, some of the most common issues that our clients are facing. One of the most common issues is people who are at risk of homelessness because they were unable to pay their rent after having a physical or mental health emergency, which meant they were not able to work. And 94% of our clients last financial year were experiencing financial disadvantage. We often see housing providers applying to evict women and their children into homelessness because they've fallen into rental debt while experiencing domestic and family violence. And almost half of our clients in the last financial year had experienced domestic and family violence. We often see people with disabilities living in properties that need urgent repairs or are not accessible for them. We see asylum seekers and refugees who are living in insecure housing, like occupancies, unable to access mainstream social housing, unable to work and unable to get a Centrelink income. And they have very little protection under the law. We also often see people leaving prison or mental health facilities who've been evicted while they were away from home and are now facing homelessness. And 55% of the people that we helped last financial year were experiencing homelessness. And our clients constantly tell us that having inadequate housing is frightening and it's dangerous. And we're constantly hearing that living in a house that's falling apart or having to go through an eviction hearing or living on the street makes our clients' mental and physical health worse. It's distressing for them, it's distressing for their children, and it causes financial distress. Which brings me to the third point, which is how do we think that a right to housing will change things? We know that a right to housing is not going to solve the housing crisis overnight. This crisis has been decades in the making, and solving it will obviously take a long-term approach. But it's a really important next step. And if the government introduces a right to housing, our clients will have stronger, clearer arguments to make when they're trying to prevent their eviction, get repairs done to their properties, get onto the priority housing list so that they can exit homelessness. They'll be able to argue not just that they have rights that relate to housing, but that they actually have a right to adequate housing. And the tribunal could take the right to housing into account when exercising its powers under the Residential Tenancies Act, which will hopefully lead to better outcomes. We think that some of the biggest changes that could come from this reform might be a little bit further upstream as well. Housing providers will understand that their residents have a right to adequate housing, and when they make decisions, for example, whether to seek someone's eviction in the first place, they will hopefully make decisions that protect that right, which would mean that our clients don't have to go through the trauma of having inadequate housing in the first place. We do not think that a right to housing is going to open the floodgates and lead to a bunch of litigation, and 20 years of the Human Rights Act has shown that to be the case. Inadequate housing that doesn't meet people's needs, has a very high individual, social and economic cost. And on the other hand, protecting the right to housing has economic and social benefits for the whole community, including, and we think this is really important, reducing the burden on the healthcare system. And I don't have time to go into it, but I encourage you to have a look at the research that's coming out of the Centre for Research Excellence in Healthy Housing at the University of Melbourne, which is looking at how inadequate housing affects health. The housing crisis is affecting everyone in this country, and we think it's very clear that there's widespread public support for change. The ACT has a Human Rights Act, and at CCL, we use that act every day to try and protect the housing rights of our clients. So we're almost there. And we think that a right to housing is going to be a small step for the ACT, but a really big leap for the way that we treat housing in this country. I'm going to pass on to Rachel, that was just a bit of an overview, and Rachel is going to tell you in a little bit more detail about some of our clients and the work that we do.
Great, thanks Ruby, and thanks for the opportunity to speak today. My name's Rachel Clark. I'm one of the supervising solicitors in the Darawang law team. I'm a Wiradjuri woman who has lived on Ngunnawal country for most of my adult life. The majority of our work in the Darawang team involves providing advice and assistance to our Aboriginal and Torres Strait Islander community in the ACT with, sadly, many issues relating to their housing. And Ruby's given you a great overview of the work we do. We talk at speed because there's large volumes of work from day to day, often with it intersecting in many different ways of people's lives. we thought that the best way to demonstrate how the right to housing might work in practice would be provide a couple of case studies, just discussing the assistance that Darawang provided, and then how the pathways and outcomes might have been different if a right to housing was in effect. So the first case study is Mary. Mary is a 65-year-old woman who was living in a one-bedroom public housing flat in the ACT. Mary's youngest daughter became incarcerated and her 2 children were then placed into care. Mary provided the children with regular care so that they could maintain their connections to the family and to their culture. Mary's son was a single father with 2 children and he needed her help with his kids because he worked full-time and sometimes he worked nights. Mary had a niece who had an intellectual disability and was homeless, and she was often couch surfing at Mary's place. As an elder in her family, Mary had provided her family with significant support. Her role as an elder was important in both passing along her cultural knowledge and in supporting her family with whatever means she has. Mary really needed a bigger house so that she could continue to provide her support and take on more responsibility for her daughter's children. It was really difficult for her to do this in the one-bedroom flat. So Mary applied to Housing ACT for a transfer to a bigger home. Her transfer application was refused on the basis that there were no formal arrangements in place for the care of any of the children or for the family members who she supported. Mary reached out to Darawang, who was able to help her put a case to Housing ACT to have her human rights recognised. It was submitted that Mary had cultural obligations as an Aboriginal elder to support her family and to ensure that their cultural heritage, connection and knowledge was sustained. Darawang submitted that the cultural and human rights of the family and children were denied by the refusal to move Mary to a suitable property where she could help to raise her grandchildren and maintain the family's kinship ties by ensuring that her home was a place that her family could congregate and stay when they needed her support. Housing ACT were persuaded by Darawang's submissions and approved Mary for a 4-bedroom property on the priority housing list, and Mary moved into a new home within a couple of months. As well as the cultural rights contained in the Human Rights Act, Aboriginal kinship responsibilities were recognised as a legitimate ground by Housing ACT to apply and obtain additional bedrooms. If a legal right to housing were introduced, Mary's case would have been much more straightforward. An enshrined right to housing would mean that access to adequate housing is recognised as a fundamental human right rather than being subject to bureaucratic discretion. Instead of having to fight for recognition, her need for a larger home would have been automatically protected under a right to adequate housing. The ACT Human Rights already provides some protections, but a stronger legal right to housing would have given Mary a clearer pathway to a secure, larger home, and it would have ensured that her family's cultural and human rights were upheld without requiring the extensive advocacy. A legal right to housing would have also removed unnecessary barriers, safeguarded Mary's role as a leader, and ensured that her family's wellbeing and cultural heritage were prioritised. It would have shifted the focus from administrative hurdles to human dignity and social justice. Our second case study is Jocelyn. Jocelyn is an Aboriginal woman who was detained at the AMC for a property crime relating to her long-term addiction issues. Jocelyn was 21 years old at the time of her arrest, and she had complex mental health and physical health issues. She suffered from depression, anxiety and addiction, as well as diabetes, which was poorly managed in the AMC, resulting in periods where she needed to use a wheelchair because her legs were swollen and painful to walk. Jocelyn had lived in public housing flats in Belconnen prior to being arrested and received a 24-month custodial sentence with a non-parole period of 18 months. She'd lived at the flat at Belconnen since she was 16 years old, having moved there directly from institutional care. Jocelyn's background had been that she lived in care since she was 7 years of age when her mother had passed away, and she'd lived in institutional care managed by a national charity until she was 16. The charity had assisted Jocelyn to secure the flat in Belconnen, and this was the only home she had known since she had lost her mother. 6 months after the commencement of her custodial sentence, Jocelyn received a notice from ACT seeking a termination and possession order to evict her from the flat in Belconnen. Such notices can be issued to incarcerated tenants because they cannot reside at the property. For Jocelyn, the loss of the flat would have had a detrimental effect on her capacity to maintain parole or reintegrate back into the community post-release. She had no family and no friends willing to offer her an address to be paroled to. She survived on her own since a very young age and had no familiar safety net which she could rely upon. Whilst in the AMC, Jocelyn had completed a number of programs on drug and alcohol addiction, and she'd been a model prisoner. Jocelyn was referred to Darawang by her caseworker at the AMC when she received the eviction notice. Darawang kept a watching brief over Jocelyn's circumstances to see if ACT's housing would proceed to apply to the ACAT for a termination and possession order to take back her property. Darawang advised Jocelyn of her legal right to remain as a tenant and advised her to continue to pay her rent in order to be in the best possible position to maintain the property should the matter proceed to ACAT. Once the notice had expired, Housing ACT waited another 6 months before applying to the ACAT for an eviction order. At this point, it was 6 months short of Jocelyn's non-parole period and 3 months short of her earliest release date. Darawang assisted Jocelyn to prepare her statement, providing detailed reasons as to why her home was an integral part of her ability to avoid homelessness and to continue on her journey of sobriety and recovery from trauma and mental illness. Darawang prepared very detailed submissions raising the interaction between the Residential Tenancies Act, the Human Rights Act, the Housing Assistance Act, and the ACAT Act and international law. Darawang then appeared before ACAT to represent Jocelyn in a 3-day hearing before 2 senior members. Housing ACT was represented by the ACT government solicitor. Darawang argued that Jocelyn's human rights, particularly her human right to dignity, were engaged by the actions of housing and any orders made by the ACAT. Evicting her from her property would have impacted on her ability to access parole, and if she was released at the completion of her sentence, she would have been exited into homelessness. If a right to housing were introduced, Jocelyn's case would have likely unfolded very differently. A legally enshrined right to housing would mean that an access to stable housing was recognised as a fundamental human right rather than a privileged subject to administrative discretion. Under such a framework, Housing ACT would have been legally obligated to ensure Jocelyn retained her home rather than issue an eviction notice simply because she was incarcerated. The rationale of managing scarce housing stock would have had to have been balanced against Jocelyn's right to adequate housing, which is recognised in international human rights law. A legal right to housing would strengthen protections for vulnerable individuals, particularly those with complex health needs and histories of institutional care. Instead of facing homelessness upon release, Jocelyn could have been supported with housing stability, which is crucial for reintegration, sobriety, and mental health recovery. It would have enforced Jocelyn's right to liberty, ensuring that her ability to access parole was not jeopardised by losing her home. A legal right to housing would have prevented Jocelyn's eviction, safeguarded her path to rehabilitation, and ensured that her transition back into society was not undermined by housing insecurity. It would have shifted the focus from administrative efficiency to human dignity and social justice. Those are just 2 of the examples. We have so many working at Canberra Community Law, which we say all the time that the ACT is a very small jurisdiction and we should be leading the way and set an example for how things should be done. Thank you.
Thank you very much, Rachel and Ruby, for that presentation. I think those case studies particularly are such a powerful demonstration of why and how the incorporating housing into the Human Rights Act could make a difference. So I really appreciate that. Thank you. So we now have some time for some questions. So I'll open it up to the floor. Please feel free to type your questions in the meeting chat, or if you want to raise your hands to ask a question directly. Well, maybe while you're thinking about what to ask, oh, yeah, that's great. We do have someone. Okay, thank you. Jules, over to you.
Okay, just had to figure out how to unmute myself. I guess I have a two-part question. I'm aware that we have, maybe not so much in the ACT, though I am aware of some vacant houses in the ACT, but we have a lot of vacant houses across the country. And I'm just wondering if enshrining a right to housing would actually enable, would it provide an avenue for requiring landlords to release vacant housing into the residential market? Housing that's just being held because then they don't have to pay land tax on it, or because they want to use it for a holiday house, 4 weeks a year, or the kinds of reasons that vacant housing just sits there underutilized. Is there a way that enshrining housing as a human right could give governments, or governments, I suppose, the capacity to do what's going to be a very unpopular move, but to free up housing that already exists?
Thanks, Jules, for that question. And maybe that goes to some of those issues around the progressive realisation, but I don't know, did Penny, or did one of the other speakers wanted to answer that one?
I can attempt an answer. Yeah. I mean, interestingly, we don't have a right to property in our Act, but there are other legal protections for private property. So I think government would have to tread very warily before attempting something. I don't think it's just that it's unpopular. I think that it's people have legal rights to those properties. So I don't really see that happening, I have to say. I don't know whether my fellow panelists have a different view, or indeed whether Mr. Rattenbury might want to offer a view on that, but I think that's probably part of the answer.
I think similarly, it's I don't think we have an answer to that question. The only answer that I can think of is that if we introduce a right to housing into the Human Rights Act, that the ACT government will then have an opportunity to take a slightly different approach to addressing housing need and the consequences of inadequate housing. And I guess that we might see that in the kind of broader policy strategies. But I think that that it will take ongoing advocacy from the community about what kinds of housing policy that we want to see to get that kind of reform to happen. It's not kind of inherent in a right to housing.
Thank you. Yeah, I think too, and without not being not having the legal expertise that our speakers have, but I think it's about broadly around having that progressive realisation, having a housing strategy, and looking at what are the means that governments can improve housing outcomes overall. Clearly, if there are a lot of vacant properties, then there are means that governments can put in place laws or taxes to try and reduce the number of vacancies. So it may not be able to compel on the basis of having it in the Human Rights Act, but if it's part of that broader approach to improving housing affordability and accessibility, then it would be something that might be consistent with the Act. So it could encourage better policies in that way, in that more indirect way, I think. Okay, Kwajo, did you have a question that you wanted to ask?
Yes, and thank you, Corinne, and congratulations on your new role. So it's a two-part question, actually. Maybe one to Matthew and maybe Mr. Rottenberry, and then the other might be for ACT Shoulder. Just curious to know how the sector gets behind this bill. What are we supposed to do? Because a lot of us agree to the fact that if this comes to light, it will, in a way, have some impact on the work we do and the support we give to Canberrans. And what role can we play? Not all of us are lawyers. Not all of us have the same expertise as Ruby from her role of work. What can we do? How do we get behind this?
Thanks. Did you want to go first, Penny, or did you want? Yeah. I can say, look, I totally agree, Quadro, and I think sometimes we know, and I think a number of the organisations who have registered are dealing with the effects of the current housing crisis, people who are experiencing homelessness. So there's certainly that recognition that we need to be doing all that we can to overcome that issue, and that this is, one part of that. As I think Ruby said, it's not going to solve all the issues, but it certainly is an important step in pushing us in that direction and providing that framework for how government makes decisions and having some accountability in how they make those as well. I think, and one thing that we will do just toward the end of the, once we have the questions, we will just talk about some things that ACT Shelter has been doing, working with ATCOS to support people to make a submission. So we certainly would be encouraging people to think about making a submission to the current inquiry that's underway in the Legislative Assembly into this bill. It is an important opportunity to show and to demonstrate that there is that support for this. And knowing that people are, really pressed for time, that it is we have developed some resources to support people with that. So we'll talk about that just towards the end of the forum as well. But certainly that is one important way, I think, that we can show and demonstrate that support. And I think, and partly why we had this as well was to try to have this forum, was to really try and have that opportunity. Not, as you say, not everyone has a human rights background, and trying to understand and connect, what does this mean, this law and the Human Rights Act, what does it actually mean in practice? How can it actually make a difference to the issues? And hopefully that's something that has been shown by the speakers, but I think it's something that we need to continue to talk about, and certainly from ACT Shelter's point of view, something that we will continue to be talking about, just so that there is that understanding and why it is significant, why it matters. So I hope that answers your question. I don't know if Dr. Mathew, if you wanted to add anything, or
look, I was just going to say what Shane, who's now left, Mr. Attenbury's just put in the chat the link to the inquiry, and I think that's certainly one way you can get behind it, by talking about the importance of a human right to housing. And even if you're not coming at it from a legal perspective, you might know of examples that, case studies I think are very, very powerful. And talking about that reframing, as Mr. Rattenbury does in the explanatory memorandum, reframing it as a right, which was something that came across very strongly in the presentations from Canberra Community Law and the Darawang program, it does make a difference to how people look at it. It may well make a difference to the way. Perhaps it needs federal government as well, of course, to look at tax incentives and so on when you're talking about things like empty housing around the place. But I think writing in a submission to that inquiry might be a very good way of trying to support housing.
So Christine, did you have a question that you wanted to ask?
Hi, yes. Firstly, I just want to thank everyone for their work and contribution, not only to this, but their ongoing work with working with people in the ACT and in Australia. My concern is, or question, I don't know, concern question, there's up to, I don't know if this is exactly right, but up to nearly 4,000 properties in the ACT that are left that with no one in them, that obviously, and I've been told that most of them get sold privately, and less than half are then, put forward for public housing. And I think it should be the other way around, but also, the knockdown and rebuild thing, then is it all about money when it comes to the end of this? Is it they're selling off more privately than they're giving more publicly? And again, people living in inadequate places. I also work for a service that, we offer transitional properties, and some of them are, in poor condition, and we have to accept that. And of course, people are very grateful for having somewhere to go, but again, I can see the disheartenment of some of our companions that we offer them to. They're although very thankful, they should not be. People should not be housed in them at the end of the day, in some of them. But we do work alongside housing, but we find it very frustrating that we can only offer certain places, and we don't have many, so we take what we're given. So it's very frustrating from this side. But yeah, that's all I wanted to ask is, what's the go with these vacant properties? People screaming for properties. Of course, we don't want them living in inadequate places with mould or whatever the issues are. But houses are not to code. There's no heating, that type of thing. Does it all come down to money? Is, I guess, where I'm coming from.
Do you want me to attempt an answer to yeah, did you want to go today?
Look, I'm assuming you're talking there about public housing properties being left vacant, or is it this relate back to the earlier question, which I kind of assumed was more about private properties, and there are various tax incentives and negative gearing and so on that encourages.
No, it's all about these are housing properties. These are public housing properties, not private.
Yeah. So I do think that if we had a right to housing in our Act, it would help shape those upstream decisions about what your housing program looks like, how you go about selling and relocating. The Commission has intervened in some social housing cases that we're still waiting for a decision on. And obviously we didn't have a right to housing. We were trying to rely on other aspects of the Human Rights Act to talk about that relocation program. But I think it's precisely when officials are coming up with plans around how they administer public housing that this right would be very important. And on some of the issues you talked about, like, is it really an adequate property? The fact that at international law, it's been spelled out that there are these 7 aspects of adequacy, because it's a right to adequate housing, not just a, shelter, roof over your head kind of thing. I think that would make a difference. And I certainly think you could then bring people to account using the public authority obligation. So that's what I would say. I'm very interested in hearing what my colleagues on the panel think.
Thank you.
Yeah, I guess I would also, and Penny mentioned, Dr. Mathew. I don't know if I should say.
Penny is fine.
I did talk about, the 2 aspects of, Human Rights Act and human rights that are in there about the progressive realisation and the immediate realisable aspects. And I think as part of that progressive realisation is looking overall at where housing policy and where the housing is tracking overall. So for us, together with ACCOS, ACT Shelter, have been strongly advocating for the importance of increasing the proportion of social housing as a, as in terms of overall housing, because we've been going backwards in recent decades. And one aspect, and again, Penny, do sort of jump in if I'm getting this wrong, because I'm not an expert in international human rights law, but one aspect when we talk about progressive realisation is that governments shouldn't be going backwards. They shouldn't be taking backward steps. So if we actually continue to see that happening, we continue to see the proportion of social housing going downwards, well, that would actually be going against what housing is as a human right if we have that in law. So it doesn't mean it goes to court and that governments are drawn before the courts, but it provides that strong advocacy tool and that framework that we can use to assess government law and policy. So it would, in that regard, provide a tool for addressing some of those issues that you raise.
Thank you.
Yeah, I don't know if Ruby or Rachel had anything they wanted to add in relation to that.
No, probably only that we do raise, Christine, like yourself, issues relating to properties being vacant for a long time. But generally we find these decisions aren't made by the people that we are communicating with, that they're sometimes developments that are flagged for demolition and sort of much higher up problems, but it does still draw back to the human right. If there was a human right for housing, then the government would be, you'd think, more moved in other arms of government to do things about these large vacancy rates. And we agree, it's very frustrating, particularly when there's long wait lists and people living in inadequate housing. But hopefully with introduction of the bill, that will improve into the future. The sooner the better. Yeah, absolutely. Thank you so much.
Okay, now we have 3 questions, and I did just notice the time. It goes fast when you're having a great discussion. So I will just, if we can just try and go through those questions fairly quickly, because as I said, I did just want to have a little bit of time at the end for us to talk about the resources that ACCOS and ACT Shelter has developed. So Andrew, if you have a question, that'd be great.
Sorry, I don't have my camera on. I'm just on my phone. But I just was interested. Very powerful examples provided by the legal people around, I guess, protecting people that are already in housing circumstances from being evicted. I'm interested whether we see this as an opportunity, or this act would maybe reorder priority, particularly in the private rental market, for people that are currently experiencing homelessness. I wouldn't say against, but in comparison to people that might be, say, relocating. My examples were at CIT, the Student Association. We obviously have students that move into the marketplace and in some regards add to this. So I'm just keen to understand, could this addition to human rights, I guess, create a, requirement or a prioritisation for people already experiencing homelessness, as opposed to, tenants who might just be relocating? Happy for the lawyers to maybe have a bit of a go at that.
Yeah, happy to hand it over to the lawyers. Yeah.
Sorry, I kept forgetting how to unmute myself. It's apologies. I am just recovered from the flu, so I'm a bit thick and slow. I think it depends on what we're talking about. So again, if it's private rental and these are properties owned by private landlords, you're then really trying to look at the legislative framework and things like incentives and taxation structures and so on. So that might encourage some shifts, I suppose. As a former academic, I have to say that I think blaming our international students in particular for the housing crisis in Australia is quite wrong.
I'm certainly not blaming.
No, I know you're not, but a lot of the public debate has been about that. So I guess there could be attempts to somehow play with the legislative framework to prioritise people who are homeless. But as I say, it's that upstream looking at the legislative framework and you have to think about the fact that if they're private landlords, they have certain legal rights in their property that you'd need to impact in some way. I bet CCL have a better answer on that than I would, because they deal with these issues at the pointy end all the time.
Thank you.
Ruby, or Rach, do you have anything quickly that you wanted to add, or?
Oh, I was just going to, if Andrew's not familiar with the eligibility for public housing, there is a requirement that an applicant will have lived in the ACT for 6 months before they can apply for housing. So in a sense, that prioritises people who are currently living in the ACT for housing. And then there is 3 housing lists, which there's not enough time for that, but people who in the greatest need essentially should be housed first.
It's probably just more thinking about the private rental market environment. In essence, to be quick, if someone has two possible tenant applications, and one is someone that's demonstrated homelessness and may or may not have the same level of rental references versus someone that does, could this act be used proactively by that unsuccessful tenant to sort of claim a right or non-discrimination, inverted commas, as a result? I think that's probably the question, so I didn't ask it particularly well.
I think the one thing I would say on this is our Human Rights Act really doesn't get into the private sector. It does not apply to us as individuals. The obligations are on public authorities, whether it's ACT Housing or the police or corrective services or whoever. So that's perhaps a limitation in our Act, that it is focused on government and it isn't necessarily focused on private individuals like private landlords. There would be opportunities to invoke discrimination law, perhaps in some of the scenarios you're thinking about, though.
Thank you. Look, we are running very tight for time, so I'll just very quickly, if Kerry and Evie can ask a question. I know Jules has put your hand up. Maybe if you could just type it in the chat, and we'll see if we can get back offline if you have an additional question. But Kerry, over to you.
Oh, hi there, everyone. Thank you very much for such an informative session. My question was just a little bit more around strategic approach to the inquiry, and just first of all, whether or not you have a sense of any potential barriers to getting a positive recommendation out of the inquiry, and whether or not organisations like ours, Australian Lawyers for Human Rights, should be thinking about addressing that within our submission, and any recommendations beyond a recommendation that the bill be passed that you'd like to see civil society getting behind in terms of a unified voice. And the other issue was, I'll just put in the chat, which is that we would really love to receive any case studies from people like Rachel or others that we could include within our submission.
Thank you. Thanks, Kerry. Yeah, did you have anything to say on any other?
Trying to read the tea leaves here.
Right.
As I say, that Labor has committed to developing a roadmap, so you would think there would be some support for the idea that right to housing should be in the Act. It's more just a matter of timing. I don't, when I look at the bill, I think it's a fairly conservative and uncontroversial one. So I don't see massive issues arising with it, particularly when you think about the fact that we've got a right to work, which doesn't even venture into progressive achievement and immediately realisable and all of those sort of hot button words. So, but I can't tell. I honestly have no real read on what are the chances. I just think it's important that community get behind it and really push it strongly, or else we'll miss this particular opportunity. There might be another opportunity down the track, but big believer in getting things done when it looks like it's possible now.
I'll just say quickly that I think one of our key kind of advocacy points that we're trying to make is that there is has in the past, when the right to housing has come up in the ACT, there's been some concern from government that there's going to be too much overlap, or there is too much overlap between federal and territory responsibilities, for example, or other resource constraints and issues like that. But we know that the government is already doing a lot, that the framework already exists, and that the housing rights are protected to a great extent, as I said. So a really key kind of plank of, I think, our advocacy is that this is not a great leap. It's just one more step, and a really important one. So that's what we'll keep saying, and hopefully that's helpful. But we're also, I think, will be very keen to keep speaking to people and talking about what how we can assist with helping people, other organisations to shape their advocacy.
Thanks so much.
And I will just go and very, very briefly, Evie, and then I'll hand it over. We'll just talk about the resources. And thank you everyone for staying on. I realise we have gone a little bit over time. So Evie.
Thank you very much. I really want to preface that, firstly, that I believe the most in need has to have to be able to access public housing, and we are looking at public housing in whatever form. But I think the backward step that happened with housing quite a while ago was that it reverted to welfare housing and it lost viability. And I think viability is a real issue with public housing, having people on moderate incomes being able to pay more and ensure that public housing was viable financially, and also removing stigma is really crucial, because it's, unless we deal with supply and that income coming into public housing, we're really going to just keep going backwards. And I understand it was absolutely necessary to address the most in need, but we really threw the baby out with the bathwater by turning what was public housing and viable, and the Canberra model was an incredibly great model without the stigma, into something that was, basically, had no fat on it, and is in a starvation mode, to put it, awfully. But if we don't, and really, if we're looking at at housing as a human right, then it needs to be across income levels as well, and not reduced. Though I do preface the most in need it, but we need to have it supported by people on higher incomes as well. Thank you.
Thanks, Evie. I might take that one just because we're running out of time as a comment, and just wrap it up there. I know I have one other question, but apologies, we're just sort of short on time. So look, thanks for all those questions. I just want to, just before we do wrap up, I just want to invite Emma Agostino, Senior Policy Advisor from ACCOS, just to speak briefly about a resource that ACCOS and ACT Shelter have developed together. Emma, over to you.
Thanks, and thanks everyone who's spoken today. It's just been really great to see so many faces here as well. So yeah, ACCOS and ACT Shelter, we are mindful that it can be quite an arduous task to put together a submission, and a number of you are working in housing and homelessness space, under-resourced, have very little time. So we've put together 2 templates. One's for individuals and one is for organisations. And so the templates are based on feedback and advice that ACT Human Rights Commission and Canberra Community Law have provided to date in this space. And so I just want to thank to both of you for all the expertise and knowledge that you've shared, and just for your persistent efforts in advocating for this reform as well. And so after this forum, ACT Shelter will circulate template to those that have attended, I know on the ATCOS end, we'll be sending an email to our members with the attached templates. And the idea is basically to use them, adapt them, amend them wherever sits in, your organisation or yourself as an individual. But just like Penny had said, encourage you to include case studies where you have them as well. And if you have any questions about the templates and the content that's in there, you're welcome to contact ATCOS. Well, we encourage you to contact ATCOS or ACT Shelter. So I'll put in the chat the best contact details for that as well. So yeah, thank you.
Thanks very much, Emma. And thank you again to all of today's speakers, Dr. Penelope Mathew, Ruby Liu, Rachel Clark, and of course to all of you for joining us today and for your engagement. As you've heard, enshrining the right to housing into the ACT Human Rights Act is an important and significant reform, and we do encourage everyone to consider making a submission to the committee inquiry. So we will be hoping also, just so you know, to make a recording of today's forum available to people upon request. We just have to figure out how to do that. So just bear with us. We may take a few days, but we will send out, as Emma mentioned, an email to everyone soon after this forum with the links to the templates. Yes, so thank you. It's been a great discussion. Really, really value the engagement and the questions. And that concludes today's forum. So thank you. Have a great afternoon and goodbye.
Thank you. Bye.